各位現場嘅嘉賓以及嚟自世界各地嘅網上參加者，大家好，歡迎繼續參與由中華人民共和國香港特別行政區律政司主辦嘅香港國安法法律論壇國安家好。法律論壇嘅第二部分現在正式開始，我哋恭請中華人民共和國香港特別行政區律政司司長鄭若驊女士發表主題演講，有請律政司司長。
尊敬嘅梁副主席、各位嘉賓、各位朋友，大家好。國安家好係今日嘅法律論壇嘅主題。國家安全係任何一個國家嘅頭等大事，係國家生存同埋發展嘅基本前提。國家安全係以人民安全為宗旨，保障每一位國民嘅根本利益，亦都係社會繁榮穩定、人民安居樂業嘅必要條件。所以，國安則家好，先有國家安全，才有美好家園。維護國家主權、安全、發展利益，堅持全面貫徹落實一國兩制，維護香港長期繁榮穩定，保障香港居民合法權益，係國家嘅堅定立場。中央以決定加立法嘅方式制定咗香港國安法，並且列入咗基本法附件3，喺去年嘅6月30日由行政長官喺特區頒布實施。過去一年，香港國安法有效遏止咗對國家安全構成嚴重威脅嘅行為同埋活動。香港國安法對維護國家安全嘅成效有目共睹，等香港走出自2019年中開始嘅困局，由亂及治。跟住呢，我會同大家講5點嘅分析，希望等大家係對香港國安法呢有正確嘅理解。第一點，香港國安法體現中央對香港特區嘅信任。香港國安法總則指出，中央政府對香港特區嘅國家安全事務負有根本責任。而香港特區負有維護國家安全嘅憲制責任。喺今年年初，終審法院喺黎智英案中清楚指出，香港國安法嘅制定係建基於維護國家安全係中央事權，並不屬於特區自治範圍。中央政府對特區有關嘅國家安全事務負有根本責任。香港國安法第40條說明，除咗第55條列明嘅3類特定嘅例外情況，其他案件，亦都即係絕大部分嘅案件，都係由香港特區行使管轄權。特區喺行使管轄權嘅時期，係依據香港國安法同埋特區本地法律，負責偵查、檢控、審判同埋處罰等事宜。喺所有國家，無論係單一制國家，又或者係聯邦制國家，維護國家安全事務係由中央政府或者聯邦政府直接負責執行，而地方政府或者州際政府呢，只有配合協助嘅角色。因此，香港特區可以對涉及香港國安法嘅絕大多數案件行使管轄權，實屬一項開創性嘅安排，展示中央政府對香港特區履行維護國家安全憲制責任嘅信心同埋信任，切實體現一國兩制嘅精神。第二點，香港國安法同本地嘅法律銜接、兼容同埋互補。全國人大常委會法制工作委員會作出關於香港國安法草案嘅說明中，提到研究起草嘅5項工作原則，其中之一就係兼顧兩地差異，着力處理好香港國安法同國家有關法律同埋香港本地法律嘅銜接、相容同埋互補嘅關係。香港國安法嘅設計同埋規定 充分體現呢一個立法原意。香港國安法係全國人大常委會制定嘅全國性法律，但係佢亦都兼顧咗國家同特區喺一國兩制下邊兩個法律制度嘅差異，確保維護國家安全嘅法律制度能喺特區切實有效執行。香港國安法第41條訂明，由香港特區管轄嘅危害國家安全犯罪案件，適用香港國安法同香港特區本地法律。另一方面，香港國安法嘅目的係維護同埋保障整個國家同埋全國人民嘅安全同埋發展利益，亦都係為咗解決香港特區喺維護國家安全方面存在嘅法律漏洞、制度缺失同埋工作短板嘅問題。所以根據第62條，如果本地嘅法律嘅規定同香港國安法不一致，會適用香港國安法嘅規定。香港國安法嘅條文反映維護國家安全嘅根本重要性。同保釋有關嘅條文呢，就係一個例子。終審法院喺黎智英案中裁定第42條第2款對有利於保釋嘅假定嘅一般規則衍生咗一個特別例外嘅情況，為保釋申請加入咗較為嚴格嘅門檻要求。喺處理保釋申請嘅時候，法官必須先決定有冇充足理由相信犯罪嫌疑人或被控人不會繼續實施危害國家安全行為的。如果法官認為沒有充足理由相信呢個人唔會繼續實施危害國家安全行為嘅話呢，佢就應該拒絕保釋申請。另一個例子係香港國安法有特別機制確保危害國家安全案件嘅公平審訊。香港國安法第46條指出，律政司司長可以基於保護國家秘密、案件具有涉外因素，或者保障陪審員同佢屋企人嘅人身安全等理由，發出證書，指示相關訴訟無需在有陪審團嘅情況下進行審理。上訴法庭喺唐英傑一案中指出，不應假設陪審團嘅審訊係刑事法律程序中達至公平的唯一方式。喺陪審團達至公平審訊嘅目的有受影響嘅風險嘅情況下呢，要確保達至公平審訊，唯有不設陪審團而由3位法官組成嘅審判庭審理案件。此舉符合控方維護公平審訊嘅權益，同埋保障被告人得到公平審訊嘅權利。第3點，香港國安法尊重同埋保障人權，維護法治。香港國安法第4條規定，香港特區維護國家安全，應當尊重同埋保障人權，依法保護香港居民根據基本法同埋國際人權公約適用於香港嘅有關規定所享有嘅權利同埋自由。而第5條亦都規定咗防範、制止同埋懲治危害國家安全犯罪，應當堅持法治原則，包括罪刑法定、無罪推定、保障訴訟權利、一事不再審等原則。而第39條呢，亦都說明香港國安法所定嘅罪行呢係冇追溯力。當然，大部分嘅權利同埋自由亦都唔係絕對，而可以係根據法律並為達至保障國家安全、公共秩序等合法目的呢而作出規定嘅限制。喺呢方面呢，香港國安法第2條強調咗基本法嘅第1條同埋第12條呢係根本性條款。香港特別行政區任何機構、組織同埋個人行使權利和自由，不得違背香港特別行政區基本法第1條和第12條的規定。 呢個正正就係個人權利同埋自由同維護國家安全之間取得嘅平衡。正如終審法院喺黎智英案中提到，全國人大同埋人大常委會呢喺草擬國安法時已經考慮並平衡咗人權因素，就係喺維護國家安全嘅同時呢，亦都要強調保障同埋尊重人權並堅持法治嘅價值。呢啲條文對於香港國安法嘅整體理解至為重要。舉個例講，言論同新聞自由受基本法同埋香港人權法案嘅保障。不過，香港人權法案第16條訂明，行使有關權利係負有特別責任及義務，可依法律規定呢，為保障國家安全、公共秩序、公共衛生或風化，或尊重他人權利或名譽而受到必須嘅限制。新聞從業員同其他人一樣，都係有義務遵守所有嘅法律，包括刑事法律。有關人權法嘅案例呢，早已確立咗負責任新聞作業呢一個概念。新聞從業員必須按負責任新聞作業嘅原則，真誠地行事，以提供準確可靠嘅資訊，方可獲言論和新聞自由權利保障。報章出版人同埋編輯亦同樣需要遵從新聞活動中嘅特別責任及義務。第4點，香港國安法具有域外效力，係符合國際法嘅原則，亦係國際通行嘅做法。涉及香港國安法嘅犯罪行為，危害國家主權、統一、領土完整同埋發展利益，同一般嘅犯罪行為唔同。如果相關嘅犯罪行為係威脅到國家安全，唔論佢係外地或者喺本地發生，犯罪者係唔係香港居民，國家都不能視若無睹，必須係予以防範、制止同埋懲治。因此，香港國安法規定咗相關嘅域外效力。呢個做法符合國際法下邊嘅保護管轄原則。喺保護管轄原則下邊，如果身處境外嘅任何人對於一個國家嘅主權進行危害同埋安全或者核心利益，譬如政府體制或者職能嘅犯罪行為，呢個主權國家係可以透過有域外效力嘅法律咧，行使刑事管轄權。不少國家嘅國家安全法都有具備呢個域外效力，例如德國嘅刑法典第5條針對叛國罪嘅域外行為，美國針對勾結外國和境外勢力活動嘅勞根法等。保護管轄原則亦都常見於反恐怖主義嘅國際公約。第5點，香港國安法第3章清楚列明構成4類罪行嘅各種具體犯罪行為及要素，以第29條勾結外國或者境外勢力危害國家安全罪為例。勾結只係條文嘅標題，而具體嘅犯罪行為就喺條文中清晰列出。制定勾結罪符合國際法嘅原則，主權平等同埋不干預他國內政係國際關係基本準則同埋國際法嘅基本原則。制定呢個罪行嘅目的係為咗維護國家嘅主權獨立，免受外部勢力干涉，佢嘅正當性顯然易見。有關罪行並唔針對，亦都唔會影響喺香港嘅機構或者個人同外地嘅正常接觸，例如學術交流啊、商業交易等。但係 喺香港嘅機構或者個人呢，都唔應該配合外國實施針對中國或者香港嘅制裁同埋其他敵對嘅行為。類似嘅罪行呢，喺其他嘅地方亦都常見嘅，例如美國針對勾結外國同埋境外勢力活動嘅勞根法，訂明咗任何美國公民，無論身在何處，喺未經美國政府授權下，直接或者間接同任何外國政府或者佢嘅官員或者代理人作書信來往，意圖影響佢哋就涉及美國爭端或者爭議嘅事宜，作出損害美國嘅措施，則屬刑事罪行。澳洲嘅刑事法典當中包含有關涉及外國干預、資助同埋接受外國情報機關資助危害國家安全等等嘅罪行。我希望以上5點能夠加深大家對香港國安法嘅正確認識同埋理解。我喺呢度衷心感謝今次論壇嘅各位講者、專家。非常多謝佢哋抽時間親身或者喺線上形式出席同埋參與今日嘅論壇，同我哋分享關於香港國安法嘅精闢見解同埋寶貴意見。我亦都特別要感謝中央人民政府駐香港特別行政區聯絡辦公室、駐港國家安全公署同埋中華人民共和國外交部駐香港特別行政區特派員公署同埋中國人民解放軍駐香港部隊對今日嘅活動嘅支持同埋協助。我亦都要特別感謝我律政司嘅同事同埋亞洲國際法律研究院嘅努力，同心協力安排呢一個論壇。最後，我希望各位參與今日嘅論壇之後呢，更能夠體會到香港國安法對國家安全同埋香港市民安定生活嘅偉大貢獻。我同埋律政司嘅同事一如既往，致力維護國家安全，務求達至國安家好。多謝各位。
多謝鄭若驊女士。下一位主題演講嘅嘉賓係中華人民共和國香港特別行政區保安局局長鄧炳強先生，有請保安局局長。
尊敬嘅梁振英副主席、律政司司長鄭若驊女士，各位朋友大家好。今日我好高興咧，係能夠被邀係獲參加由律政司主辦嘅香港國安法法律嘅論壇。喺上晝嘅主題演講同埋座談會入邊咧，以及啱頭先律政司司長嘅發言咧，主要都係從法律嘅角度咧去睇下香港國安法，作出一啲深入嘅研討。我喺度咧係想借呢個機會，係從執行香港國安法嘅方面，同大家講述一下我哋保安局連同我哋嘅紀律部隊喺維護國家安全方面工作嘅經驗。香港國安法實施嘅效果，同埋香港喺維護國家安全方面所面對一啲嘅挑戰。自從2019年6月份開始，喺年幾嘅時間入邊我哋面對黑暴肆虐，相信大家都唔會忘記。暴徒肆無忌憚咁樣破壞商店、鐵路同埋其他公共嘅設施，縱火、強闖同埋破壞立法會，肆意毆打持唔同意見嘅人。外部勢力嘅干預係非常嚴重，有人乞求外國去制裁中國同埋香港特區政府，更加有人圖謀要顛覆國家政權。香港面對前所未有嘅國家安全嘅威脅。上述嘅黑暴係涉及3個同國家安全相關嘅重要元素，分別係外國勢力插手破壞、港獨嘅肆無忌憚，以及暴力同埋破壞嘅嚴重程度。我喺以下嘅時間會就各個元素為大家作出一啲嘅分析。第一，外國勢力係為咗自身嘅政治利益，透過唔同嘅途徑，包括提供資金同埋物資俾佢哋喺香港嘅代理人，推動同埋支持香港嘅暴徒嘅暴行。一個同外國政府有聯繫嘅組織， 喺自己嘅國會聽證會上邊咧，係曾經公開承認曾經撥款係俾香港嘅暴徒喺網絡上邊隱藏自己嘅身份，逃避追查。亦都有境外嘅組織咧喺黑暴期間公開為暴徒係籌款同埋籌集物資同埋裝備，包括頭盔、防毒面具同埋一啲濾芯等等。我相信大家都察覺得到咧，喺黑暴肆虐期間，暴徒係具有高度嘅組織性。而且咧喺每次暴亂過後都會留低大量嘅物資，毫不吝嗇，可見資金同埋物資嘅供應咧係非常充裕嘅。第二個元素係港獨嘅肆無忌憚，大約喺10年前，抗拒國家嘅本土主義同埋帶有自決港獨意識嘅活動開始冒起，其後咧係發生咗2012年嘅反國教事件、2014年嘅非法佔中，同埋2016年嘅旺角暴動，同埋2018年因為鼓吹港獨而被禁止嘅香港民族黨等等嘅事件。去到2019年嘅黑暴事件入面，鼓吹港獨嘅人係揮舞港獨嘅旗幟，展示港獨嘅標語，呼喊港獨嘅口號，公然咧係挑戰中央同埋特區政府。第三係黑暴期間暴力同埋破壞嘅嚴重程度係前所未有嘅，暴徒係掟咗超過500個汽油彈，我哋警方咧亦都檢獲咗超過1萬個汽油彈，其中喺一次事件入邊咧更加搜獲咗3900個汽油彈。此外喺黑暴期間咧係大約係有22000平方米嘅行人路磚係俾人拆走，即係幾大咧？即係2個香港大球場咁大，可以鋪滿。被拆除嘅欄杆嘅長度咧係超過60公里，即係長過由石澳去到我哋赤鱲角機場。更加有人咧係不幸俾暴徒係用磚頭係掟死，亦都有人咧係俾暴徒用易燃嘅物體咧係淋上咗身度，然後係再點火，以致到身體咧係嚴重燒傷。黑暴大大削弱咗香港人，特別係年青人嘅守法意識。有人呢係刻意去散播一啲錯誤嘅意識，宣揚只要自己認為係啱嘅嘢，犯法都可以做。好多年青人就係咁樣咧，係俾人推咗入去犯法嘅深淵，要坐監同埋要留有案底。香港國安法喺舊年6月30號頒布實施，效果係立竿見影，發揮咗震懾力，令到香港由亂變治，市民嘅生活咧係回復正常。經濟同埋民生咧都可以重新出發。喺建立維護國家安全嘅法律制度上面咧，香港國安法帶嚟嘅效果主要係體現咗喺2個方面。第一，香港自回歸以嚟，由於未能夠就基本法第23條立法，喺維護國家安全方面咧嘅法律係存在咗一個嘅漏洞。香港國安法係填補咗呢方面嘅漏洞，清楚定明咗4類危害國家安全嘅罪行，當中嘅勾結外國或者境外勢力危害國家安全罪，係有助防止外部勢力同埋港獨嘅勢力係連成一線，減低係受外部勢力干預嘅風險。至於顛覆國家嘅政權罪咧，就可以減低係有人透過發動顏色革命，企圖去奪取管治權嘅風險。至於分裂國家罪，即有助咧係遏止港獨嘅分子從事分裂國家嘅行為。此外，香港國安法係強化咗現行法律入邊針對恐怖活動嘅法律框架，定明咗咧為脅迫中央人民政府、香港特區政府或者國際組織，或者恐嚇公眾意圖實現政治主張、組織、策劃、實施、參與實施或者威脅實施造成嚴重嘅社會危害嘅恐怖活動，即屬犯法，令到執法部門咧喺處理危害國家安全嘅恐怖活動方面咧係有法可依。喺執法方面，自從香港國安法生效以來，我哋警方一共咧係拘捕超過咗110人。雖然同黑暴期間被拘捕嘅超過1萬人比較咧，只係算好少嘅數目。但係有關嘅執法行動咧，已經成功打擊咗大部分呢啲嚴重嘅危害國家安全嘅犯罪活動。喺被捕人士當中，係包括圖謀透過所謂35+初選 去涉嫌顛覆我哋國家政權嘅團夥，同埋咧係以新聞工作做包裝，涉嫌串謀勾結外國勢力，危害國家安全嘅人物。香港國安法係發揮咗強大嘅震懾力，以前參與勾結同埋外部勢力聯盟嘅人咧，紛紛退場，有人解散咗自己嘅組織，亦都有人咧係潛逃咗去咗外國，國家安全風險咧係已經大為減少。但係我哋咧絕不能夠掉以輕心，喺維護國家安全方面，我哋仍然要面對唔少嘅挑戰。喺治安方面，社會嘅整體守法意識，特別係年輕人方面咧，係仍然薄弱。雖然近期整體罪案數字係有所下跌，但係黑暴咧已經大大削弱咗香港人嘅守法意識。更加令人擔心嘅係咧，香港近年係出現咗犯罪年輕化嘅情況。青少年被捕人數咧喺2020年咧係比2018年係增加咗係超過40%。我哋亦都睇到近期涉及青少年嘅犯罪個案係非常嚴重，包括有中學生係俾另外一啲青少年咧係濫用私刑，被掌摑、拳打腳踢，亦都有青少年咧係3、5成群去打劫金鋪、販毒、刑事毀壞等等，呢啲事件咧都係令人痛心。此外，雖然香港國安法嘅實施係壓止咗黑暴、港獨嘅囂張嘅違法嘅行為，但係港獨分子咧係並冇完全放棄，仍然係死心不息，繼續利用媒體、文化藝術同埋刊物等等呢啲不同嘅軟對抗嘅方式，進行鼓吹同埋滲透，去灌輸港獨嘅思想。近期不時咧，仍然係有人宣揚港獨嘅組織，喺唔同嘅地方擺設街站。亦都有大學嘅學生會嘅內閣咧，喺參選嘅宣言入邊咧，係同埋政綱入邊咧，仍然係將暴徒咧係稱為義士，係宣稱要對抗政權。有港獨分子係為咗係規避調查咧，不斷改頭換面，成立新嘅組織，並且係招攬新嘅會員。有人咧以播放紀錄片為名，以文化滲透暴力、港獨為實，美化暴徒。亦都有書店咧喺售賣教學同埋兒童圖書嘅期間，係出售宣揚抗爭嘅書籍、攝影集、小説或者自傳等等，去荼毒我哋嘅年輕人。因此我哋咧係要保持警覺，亦要呼籲香港市民咧係遠離被港獨騎劫嘅活動，唔好俾人咧係利用作為港獨嘅保護傘。另一個挑戰就係本土恐怖主義嘅潛伏。黑暴至今一共有超過20宗係涉及爆炸品、槍械或者子彈嘅案件，檢獲嘅爆炸品咧都係外國恐襲常用嘅炸藥。今年4月，法庭就一宗咧係涉及相關炸藥嘅案件，判處被告12年嘅監禁。喺另一宗案件入邊咧，我哋警方係檢獲咗2個共重約10公斤嘅土製炸彈，一旦引爆咧係足以炸冧100米範圍入邊嘅建築物。另外有一宗案件，我哋警方係檢獲咗一支咧係半自動步槍，同樣嘅步槍喺美國拉斯維加斯曾經俾人咧係利用嚟咧係向一啲出席音樂會嘅人咧嘅人群掃射，造成係有50幾人死亡。最近一宗嘅案件發生喺今年6月份，我哋警方係搗破咗一宗咧係涉嫌藏有爆炸品同埋仿製槍械嘅案件，被捕人士喺社交網站聲稱要殺死多名嘅知名嘅政治人物，同埋要血洗警署，種種跡象咧顯示香港係潛藏住呢啲嘅本土恐怖主義嘅風險。犯案嘅人係有能力、有知識，更加有實際嘅行動咧去策劃呢啲本土恐怖主義。我哋更加要防範自我激化嘅人，佢哋表面上咧係好正常，但係可以咧突然係變成孤狼，做出一啲咧恐怖嘅行為，造成嚴重嘅死傷。就喺啱啱嘅7月1號，就有人咧係突然用利刀去拮向一個正在執勤嘅警員，然後自殺。初步調查顯示咧，正就係呢啲所謂孤狼式嘅本土恐怖襲擊。但係仍然有人咧係繼續誤導同埋荼毒市民，嘗試美化、英雄化呢啲嘅行為，甚至係將責任咧係推俾警方。我哋必須要咧係嚴正譴責。針對以上嘅風險，除咗嚴正執法之外，我哋亦會加強情報分析嘅工作，令到罪行咧係能夠防範於未然。我哋亦會透過宣傳同埋教育，重建守法嘅意識， 以及咧向市民講解時常見到嘅犯罪手法，令到市民咧係提高警覺。喺呢方面，政府、保安局同埋我哋轄下嘅紀律部隊以及社會各界都要共同努力，重建正確嘅價值觀同埋守法嘅意識。喺過去一年，喺香港國安法嘅開局之年，雖然咧係仍然有上述嘅潛在風險，需要我哋繼續去處理，但係香港國安法嘅震懾力咧係已經顯露無遺，對維護香港嘅安全同埋穩定成績係有目共睹。但我想強調，香港國安法係一部全新嘅法律，喺執行過程中咧係需要理順法律唔同方面嘅實施細則。就此咧，我哋保安局同埋警務處嘅國家安全處係得到律政處嘅大力支持同埋協助，就調查案件嘅時間咧所需要採取嘅執法措施嘅法律依據，同埋進行檢控時間嘅相關嘅罪行嘅條文嘅詮釋，相關證據是否充分，以至當執法同埋檢控工作都受到法律挑戰嘅時間，我哋控方係應該提出邊啲法律依據等等咧，都係俾咗好多專業嘅意見我哋。喺處理上述嘅事件當中，律政司嘅同事做咗大量嘅研究工作，並同我哋保安局同埋負責有關案件嘅國家安全處嘅同事咧係緊密溝通，令到有關嘅法律同埋司法程序咧都得到最妥善嘅處理，喺執法行動咧得以暢順同埋有效咁樣進行。我對此咧感到非常感謝。踏入香港國安法實施嘅第2年，隨住執法同埋宣傳工作嘅雙軌進行，法庭亦都開始就危害國家安全嘅犯罪嘅案件進行審訊同埋判決。市民同埋社會各界咧嘅國家安全意識將會進一步提升。保安局會一如既往帶領我哋紀律部隊，堅定不移咁樣咧係履行維護國家安全主權、安全同埋發展利益嘅責任，竭盡所能做好維護國家安全嘅工作。保安局同我哋轄下嘅執法機構亦會繼續同律政處咧係緊密合作，以認真、不偏不倚同埋無畏無懼嘅態度去執行香港國安法，繼續為國安家好嘅目標係作出貢獻嘅。多謝各位。
多謝鄧炳強先生，係一位主題演講嘅嘉賓，係中華人民共和國香港特別行政區前終審法院常任法官列顯倫先生。有請列顯倫先生。
Thank you, Secretary of Justice, for inviting me to take part in this forum. Such a small contribution as I can make to your deliberations come from long years in the law, in the course of which I've learned at least one thing: honor the wisdom of the common man, for therein lies the essence of the common law. And a subsidiary lesson perhaps is this, that history casts a long shadow. Now, in 1815, China, under the rule of the Emperor Jia Qing, was at peace. But Britain, in the course of acquiring a great empire, was at war, and it had been so continuously for 20 more odd years. Now, when, after the Battle of Waterloo in June 1815, the Duke of Wellington, the commander of British forces, was asked how he saw the outcome, his laconic reply was, "It was a close-run thing." Now, his foot soldiers, formed in squares, withstood the repeated onslaught of Napoleon's fearsome cavalry. Not a single square broke rank. Discipline ultimately prevailed. Now, transposing the scene from the heights of Waterloo in June 1815 to the streets of Hong Kong in November, December 2019, what do we see? The police force in serried ranks, protecting property, safeguarding lives, staying calm and restrained, withstanding onslaughts by assailants, wearing protective gear, weapons grade gas masks, wielding sharpened iron rods, throwing petrol bombs. And they did this month after month. Now, I put myself in the place of the ordinary policeman. He had been doing this for more than 6 months. His name has been posted on social media. Doxing involved not only himself, but also his children. They are bullied at school. The quarters where he lived have been firebombed. His wife is seriously frightened, and his mother-in-law says to him repeatedly, "Why do you protect other people's property and not your own home, your own family?" She might even have added, when ordered to make an arrest, he's required to exercise reasonable force, whatever that means. Now, the thug he's arresting knows no reason, no restraint. An arrest risks serious injury to himself, and some of his colleagues had been injured and hospitalized. The thug carries no ID card. He will not disclose his name, will not cooperate in having his photo or his fingerprint taken. He will not accept police bail. He cannot be charged. So, after 48 hours, according to law, he has to be released unconditionally to repeat the same outrage the next weekend. Now, how close was Hong Kong then to total collapse? Now, this we ordinary citizens will never know. This is something the government, for obvious reasons, will never disclose. But as an observer, looking from the outside, I would say it was a close-run thing. All it took was for one police unit to break ranks to say, "We've had enough." The whole force would have collapsed, but discipline held, and for that, the community should be forever grateful. Now, this, as I see it, is the true scenario against which the national security law should be viewed. The rest is creative fiction crafted to put the Hong Kong government in the worst possible light. What Hong Kong faced was an insurgency, the overthrow of government, nothing less. Now, the insurgents made the classic mistake of the cowardly, of the schoolyard bully. They took the government's low-key response, its restraint, as signs of weakness. So for a few months, the leaders strutted on the stage as if they owned the whole show. They attracted the label of freedom fighters and got themselves onto the cover of Time magazine. They took no responsibility for the misery they caused to millions of their fellow citizens and the billions of dollars of damage they inflicted to be paid for by Hong Kong taxpayers. Now, what happened on Sunday, 18th August 2019, is a good example. The police had raised no objection to a mass gathering in Victoria Park, provided the organizers arranged for 200 marshals to control the crowds. But the police objected to a procession to Central and a further mass gathering there. Now, in open defiance of the law, the leaders raised a huge banner and led a procession down the highways to Central, vaunting their impunity from the law. So filled were they with their own sense of triumph that they forgot the inherent strength of the law, that the law has long arms. In retrospect, it can be seen that the seeds of insurgency were laid many years before. As Professor Cullen recently explained, much of the world had been dominated by the notion of Western ascendancy for some 200 years. China's decline in the late Qing dynasty had been accelerated by Western belligerency. But after World War II, the balance began to shift. Now, the USA, for all its awesome firepower, met stalemate in Korea, defeat in Vietnam, and expulsion in Cuba. Then came the astonishing rise of China after the end of the Cultural Revolution in the early 1980s. The tectonic plates began to shift, but there was no change in Western thinking. It clung tenaciously to the notion of Western ascendancy. One aspect of this, as Professor Cullen puts it, is, quotes, turbulent pushback from an unnerved Western media. Now, this pushback reflects the stance of Western powers clinging to its assumed ascendancy. With the breakup of the Soviet Union in the early 1990s, China was seen more and more as posing a threat to the dominance of the West. How to counteract that? Destabilize Hong Kong was one answer. The thinking seems to run along these lines. China stands today as a strong, homogeneous nation state, but it wasn't that long ago that China was splintered into separate fiefdoms, dominated by warlords. Well, maybe territorial integrity could be broken up again. Now, the stirrings of industrial action in the late 1980s in a lousy little shipyard in Gdansk, Danzig in the old terminology, a small port on the Baltic Sea, could lead to the eventual breakup of the Soviet Empire. Why wouldn't the seeds of insurgency sown in Hong Kong do the same thing to China's territorial integrity? The signs of such a movement are everywhere to be seen. We need to look no further than at how the controversy surrounding the national security law arose. Now, as everyone knows, the Basic Law Article 23 required the Hong Kong SAR on its own to enact laws to prohibit treason, secession, subversion, etc. Now, the laws in the statute books inherited from colonial times, scattered in fact over 3 ordinances, were plainly unfit for that purpose. So, 5 years after reunification, the government issued a consultation paper on proposals to implement Article 23. It made out a strong case. Now, this is what it said, quotes, all countries around the world have expressed provisions on their statute books to prevent and punish crimes which endanger the sovereignty, territorial integrity, and security of the state. Therefore, while nationals of a state enjoy the privilege of protection provided by it, on the one hand, the individual citizens have a reciprocal obligation to protect the state by not committing criminal acts which threaten the existence of the state, and to support legislation which prohibits such acts, on the other hand, unquote. The proposal took into account a whole range of constitutional guarantees of personal freedom, speech, expression, the press, freedom from arbitrary arrest, sanctity of the home, etc., etc. All thinking persons would have realized that to implement Article 23 was an absolute necessity. The central government had entrusted this to the Hong Kong SAR. It was a considerable responsibility. Now, what was required was not a regional security law, it was a national security law affecting not only security within the region, but nationally. To emphasize Hong Kong's high degree of autonomy, this law was to be enacted by the SAR, quotes, on its own, unquote. When the National Security Legislative Provision Bill was introduced in LegCo in February 2003, one would have thought that all community leaders would have given it their support. But if there were flaws in its details, these could be ironed out in committee. There was no rational basis for a total rejection of the bill. There was only one possible alternative to the enactment of the law by the local legislature, its promulgation by the central government. But misinformation got to work in the social media. People's passions were aroused. Dark forces were at play to defeat the bill, and it failed to pass. So, fast forward now to early 2019. The controversy surrounding another piece of legislation, the Return of Fugitive Offenders Amendment Bill. The international community was at that time much concerned about cross-country crimes, money laundering, and terrorist financing. Now, to align Hong Kong with other developed economies, it was necessary to upgrade the existing ordinance, hence the amending statute. A scare campaign was mounted through social media. The bill was portrayed as allowing mainland agents to grab people off the streets of Hong Kong and bring them to trial across the border. Trouble in the streets erupted, turning into the most damaging unrest Hong Kong has ever seen. This is what Mr. C.H. Tung, former chief executive, said in May 2019, quotes, "As Hong Kong has failed to enact its own security legislation for over 20 years, it had become an easy target for hostile foreign opportunists to disrupt public order, using Hong Kong in effect as a proxy for a wider power conflict," unquote. On Wednesday, 12th June 2019, an organized group of rioters outside the fence perimeter, fighting to get into the Legislative Council building, forced the suspension of the second reading of the bill. Now, 3 days later, the government announced the withdrawal of the bill. The speech made by the chief executive was calculated to calm nerves and dampen passions. It was a model of restraint and humility. She said this, "I want to stress that the original purposes of the exercise stem from my and my team's passion for Hong Kong and our empathy for Hong Kong people. I feel deep sorrow and regret that the deficiencies in our work and various other factors have stirred up substantial controversies and dispute in society following the relatively calm periods of the past 2 years, disappointing many people. We will adopt the most sincere and humble attitude to accept criticisms and make improvements so that we can continue to connect with the people of Hong Kong," unquote. Now that surely would have satisfied demands of the protesters. Their aim had been achieved, the withdrawal of the bill, but not at all, showing beyond doubt that the movement had much deeper and darker roots. Now, Monday, 1st of July, was a public holiday to celebrate Hong Kong's reunification with the mainland. On that day, an organized group broke into the Legislative Council building and trashed the Legislative Council chamber. The national emblem was defaced. The Hong Kong colonial flag was raised. The rioters had, in effect, declared war on the government, on the existing constitutional order. It was a war on democracy, just as it was in 1933, when Hitler's thugs burned the Reichstag, the German parliament. This was the moment for the veteran leaders of the democratic movement, the pro-Dems members of LegCo, to distance themselves from the movement, to condemn acts of violence and desecration, not one bit, thereby allying themselves inextricably with the violent segment of the movement. Fast forward again to 11th to 12th July 2020, soon after the enactment of the national security law. Various agitators had got together to mount what they called primary elections to find the best candidates for the electoral elections due to take place later that year. They've since been arrested on suspicion of subversion under the new national security law. Now, in a report to Parliament this month, the British Foreign Secretary Dominic Raab said that the national security law was being used to, quote, stifle political opposition, unquote. It seems, sadly, that the Foreign Secretary had not been told the full facts, or is it possible that someone of that standing would knowingly distort the truth? Because most of the truth of that story is actually on public record. The so-called primaries were simply a small part of a larger plot calculated to bring down the government. This was described as, quotes, 10 steps to mutual destruction, unquotes, which had been outlined in Apple Daily in late April 2020, last year. The label attached to this plot is Lam Chao, in English, we burn, you burn, an expression taken from a popular TV series. It was on its face a last desperate attempt by the insurgents to bring down the government. Now, the full facts have not been revealed. Investigations are still going on. The degree of culpability of the individuals have not been assessed. The case has yet to come on for trial. What, for instance, was put to the voters to induce them to come out and vote in the primaries? Probably different things were said to different constituents, and there may be questions as to the truthfulness of what was said. According to the police, the voters were paid substantial sums to take part in the process. Arising from this, apparently, 1.6 million Hong Kong dollars have been frozen. The significance of this will be reviewed later on at trial, presumably. Under such circumstances, how could it possibly be right for the British Foreign Secretary to assert that the national security law is being used to stifle dissent or opposition? As things stand today, there is a bill in the British Parliament entitled, quotes, Police Crime Sentencing and Courts Bill 2021, unquote. It is meeting with considerable opposition from ordinary citizens who have launched street protests. Now, this is what the policy paper supporting the bill says, quotes, protests are an important part of our vibrant and tolerant democracy. Under human rights law, we all have the right to gather and express our views, but these rights are not absolute rights. That fact raises important questions for the police and wider society to consider about how much disruption is tolerable and how to deal with protesters who break the law. A fair balance should be struck between individual rights and the general interests of the community, unquote. Section 59 of that bill, for instance, abolishes the common law offense of public nuisance and replaces it with a statutory offense of very wide scope, attracting 10 years imprisonment on indictment. Now, would it be right for, say, the Hong Kong Chief Secretary to comment on this provision, on how the, quotes, fair balance should be struck in the UK? Obviously not. So how is the reciprocal position justified? What is more, the national security law deals with something more fundamental than the so-called fair balance. It arms the Hong Kong government for the first time since reunification with effective legislation to deal with an insurgency. The law starts with general principles, where the lawful rights and interests of Hong Kong residents are fully protected. The common law principles governing criminal trials are safeguarded, including, for instance, the presumption of innocence, the exclusion of prejudicial evidence, etc. If one looks, for instance, at the US Patriot Act of 2001, the contrast with Hong Kong's national security law is stark. That is an act to deter and punish terrorist acts in the USA and around the world. It is extremely difficult to judge from the text of that law its overall effect, for it is not only an enabling act, but also an amending act, amending many other enactments. So unless one is familiar with those other enactments, it is simply not possible to make sense of the Patriot Act of 2001. But its introduction paragraph is startling. It says, quotes, "Any provision of this act as applied to any person or circumstance shall be construed so as to give it the maximum effect permitted by law, unless such holding should be one of utter invalidity or unenforceability, in which event such provision shall be deemed severable from this act," unquote. There's no mention of presumption of innocence, no safeguards for the rights of the defendant. The repeated accusations made by Western leaders and media of Beijing's so-called stifling of freedoms in Hong Kong through the use of the national security law is so far from reality that the conclusion is inevitable. As Mr. C.H. Tung said, Hong Kong is being used as a proxy for a wider power conflict. Thank you.
接住落嚟係今日嘅第三節，亦都係最後一節嘅座談會，主題係國家安全法的比較研究。主持人係香港城市大學法律學院教授朱國斌教授。講員有香港大學法律學院客座教授高禮文教授、香港中文大學法律學院卓文法律學教授 Chin Ling Lim 教授，以及海牙國際司法會議亞太區域辦事處代表趙雲教授。有請朱教授。
Distinguished guests, dear colleagues, ladies and gentlemen, good afternoon. The passage and the implementation of the Hong Kong national security law was an unexpected move to many people, but it was still a logical development. The national security law has quickly achieved the goal of stabilizing society, restoring order, and rebuilding confidence. The central government directly exercised the legislative power to maintain national security for the Hong Kong SAR, which was constitutional and lawful. The aims of the central government are to prevent and punish any acts that endanger national security, which, while urging SAR government to fulfill its constitutional obligation to maintain national security. The adoption of the law and its implementation in the SAR will undoubtedly bring about political, legal, social, practical, and many other far-reaching influence on Hong Kong. And this influence will be constitutional, institutional, long-term, and far-reaching, and its extent will even exceed people's expectation. As far as the influence on Hong Kong's legal system is concerned, it will be reflected in constitutional order, human rights protection, criminal law, criminal procedure, and the judicial system. In view of the fact that Hong Kong national security law has only been implemented for 1 year. Many questions and the difficulties have not been fully revealed. This means it is most necessary to continue to observe the law operates and to carry out a full in-depth discussion and research. Following the discussion on the substantive law aspect and on the procedural law aspect of the Hong Kong national security law in the previous 2 sections of the legal forum this morning, we now enter the 3rd section, comparative study of national security law. It is the fact that most of the countries and the regions in the world have enacted their own laws to safeguard national territorial integrity and sovereignty. National security involves fundamental interest of a given country or a given region. In view of the differences of a political system and the legal systems, the legal provisions governing national security understandably vary between one jurisdiction and another. However, there must be some common values, principles, systems, and even legislative techniques and the experience which apply. This is the subject of our discussion. For this reason, this forum is honored to have invited 3 leading scholars to share the research result and the observation with us. They are Professor Richard Cullen from the Faculty of Law of the University of Hong Kong, Professor Treason Lim from the Faculty of Law of the Chinese University of Hong Kong, and Professor Zhao Yun from the Faculty of Law of the University of Hong Kong, who also served as the representative of the regional office for the Asian and the Pacific of the Hague Conference on Private Intellectual Law. I'm Zhu Guobin, Professor of Law at the City University of Hong Kong, and also a member of the International Academy of Comparative Law. Professor Richard Cullen is a visiting professor at the Faculty of Law of University of Hong Kong. He once taught at Monash University, Australia, and the City University of Hong Kong. He has been a visiting scholar at the universities in Australia, Canada, Belgium, China, England, Japan, and Switzerland. Has made presentations at the seminars and conferences in various countries and the regions. He has written and co-written several books and over 200 articles, notes, and commentaries. Today, Professor Cullen will speak on national security law comparing Australia and Singapore. Professor Treason Lim, now a professor at the Faculty of Law of Chinese University of Hong Kong, is also a visiting scholar at King's College, London, and an honorary senior fellow of British Institute of International and Comparative Law. His books cover international law, international investment law, and arbitration. I want to highlight that he has co-edited Law of the Hong Kong Constitution. Professor Lin will speak on national security law, Anglo-American comparisons. Professor Zhao Yun, Henry Chen Professor in International Law and Head of the Department of Hong Kong of the University of Hong Kong, is also a visiting professor at the various distinguished universities in the mainland China. Professor Zhao is currently a standing council member of the Chinese Society of International Law and a member of Asian Pacific Law Association and the Beijing International Law Society. Professor Zhao is going to speak on national security law from international law perspective, with a special reference to European continental practice. From the outline of the presentation prepared by the panelists, we see that a wide range of topics and issues will be specially covered and discussed with reference to Hong Kong law and practice. They are constitutional order and national security law, role of the state, legal regime of national security law, law enforcement entities and the mechanisms, extradition and the political offenses, extraterritorial application of law, individual rights under national security law, tension between the protection of public interest and that of individual rights and liberties, and finally, the role of the court. Now, we invited the panelists to start their presentation. The sequence is Professor Cullum, Professor Lim, and Professor Zhao. Thank you. Okay. That's good. I'm looking for my PowerPoint slides, but they'll come, I'm sure. Good afternoon, distinguished guests and friends, and thank you, Professor Zhu, for the introduction, and many thanks to the Department of Justice for asking me to speak at this forum. I can take this off now too. In an ideal world, there would be no need for national security laws. We live in a wonderful world, but it is far from ideal. And we received a stunning reminder of this certainty here in Hong Kong in 2019. The insurrection, which grew out of a series of major protest marches, had established traction by early June in that year, and it grimly continued for many subsequent months. I wonder if that'll work. Here we go. In the normal real world, national security laws have been applied in various forms for many centuries. The Treason Act, for example, codified the common law offence of treason in England in 1351 during the reign of the Plantagenet King Edward III. National security laws have grown significantly more detailed and complex over time. Context matters. After the 9/11 attacks in 2001 in America, there was a major lift in national security legislating right around the world, led by the US, as has been explained very well by the Secretary for Justice just a little earlier. Consequently, the scope of the matters that I will discuss today is very wide, and accordingly, I'm going to use my time in the following way. Firstly, to summarise key aspects of the Australian national security framework. This will be a very concise summary, and then review also, again concisely, the national security framework in Singapore. And then I want to refer briefly, but I hope in an informing way, to case studies illustrating the operation or impact of these national security regimes in Australia and Singapore. Here we go. So firstly, to look at key aspects of the Australian national security regime. And I want to start off by talking a little bit about something I think most of you will have heard of, the Five Eyes Security Alliance. This Five Eyes Security Alliance was originally Two Eyes, the UK and the US. Their code breakers had established a most useful working relationship during World War II in accordance with the Atlantic Charter, which had been agreed to in 1941, shortly before the US joined or entered the war. In March 1946, the US and the UK signed a secret treaty, in effect creating the Two Eyes, which linked the work of the US National Security Agency, usually referred to as the NSA, and the UK Government Communications Headquarters, which is normally referred to as GCHQ. Canada joined the arrangement in 1948, and Australia and New Zealand joined in 1956. Certain other countries which had some involvement in this Five Eyes Alliance, or alliance as we know it, withdrew in due course, and the alliance was then confirmed as the Five Eyes, consisting of the 5 leading English-speaking allies from World War II. The Five Eyes Alliance has served a very important role for its members in providing enhanced joint security support and a framework. In 2013, leaked documents provided by a short-term visitor to Hong Kong, Edward Snowden, who once worked for the NSA, revealed that alliance members did not just spy on foreign parts, but spied on one another's citizens. And then they shared the collected information with each other. This was handy as it provided a way around domestic national security laws which applied restrictions to spying on your own citizens. The Alliance also helped orchestrate, through security service collaboration, covert political intervention in foreign countries, which included the overthrow of governments in Iran in 1953 and Chile in 1973. Let me now move on to the extensive Australian legal framework governing national security, and I'm going to summarise quite a bit here, but I believe the gist of a longer paper will be published shortly. The Australian Government website provides a summary of both the primary national security laws which apply and the varied national security agencies in Australia which operate under those laws. Now, note, these are federal laws. That's all I'm talking about here today. I don't have time to go more, but there are additional relevant laws which operate at the state level in Australia. So we're just talking at the federal level. And the federal summary just lists the most prominent national security laws. Let me just briefly mention a handful of these. Firstly, there's the Crimes Act from 1914, which is significant. Another very important piece of legislation is the Criminal Code Act from 1995. And most recently, a very important piece of legislation, the full impact of which we'll have to see unfold over coming years, has a long name, but it's usually called the Foreign Interference Act from 2018, which I believe has helped encourage imitations in other jurisdictions, including, I think, the UK. The security agencies which operate in Australia include specialised agencies and other institutions which are general policing institutions, but which have particular security responsibilities. And briefly, these are ASIO, which stands for Australian Security Intelligence Organisation, and its role is primarily to deal with domestic security responsibilities. ASIS, A-S-I-S, is the Australian Security Intelligence Service, and its primary role is in offshore security operations. Then there's the Australian Federal Police, the Australian Border Force, the Australian Criminal Intelligence Commission, and the Australian Transaction Reports and Analysis Centre. Significant enhancement is coming for all of these agencies, both in terms of yet more law, but also quite a lot more money as a result of a major review of the security system in Australia, which I'll speak about in a moment. But briefly, Australia has at least 13 major national security laws, including the sweeping revisions in the Foreign Interference Act, recently passed, and 6 key agencies devoted to applying those laws. The laws listed cover a huge number of topics, but let me just mention a number of them. The usual sorts of things: treason, treachery, sabotage, piracy, espionage, terrorism, terrorist financing, hostage taking, interference with ships and aviation, foreign interference in domestic politics in Australia — this has moved up the agenda significantly recently — and foreign incursions into Australia. The Criminal Code Act of 1995 also has some extraterritorial scope, making it an offence to cause serious harm to an Australian outside of Australia recklessly or intentionally, assuming you can get a hold of the person who did the serious harm. Evelyn Douek, a rising Australian legal academic, recently argued that under the new Foreign Interference Act passed in 2018, and I quote from her article, "It is illegal for a person to knowingly engage in covert conduct or deception on behalf of a foreign principal," very widely defined, by the way, a foreign principal, "on behalf of a foreign principal with the intention of influencing an Australian political process, exercise of the vote, and so on." Quite wide scope. The maximum penalty, if you breach this new provision, is 20 years imprisonment if the conduct is intentional, and 15 years imprisonment if it's done recklessly. Other provisions criminalise influencing a target in relation to any political process. Douek says that the reach of these provisions is vast. Now let me talk briefly about the major review which has just recently been completed of the national security system. It was conducted by Dennis Richardson, a former head of ASIO, so it's got a very strong focus on national security from somebody who knows a lot about it and whose living depends on protecting Australia's national security. It notes that since the 9/11 attacks in 2001, over 120 acts have been brought before the Australian Parliament, federal Parliament that is, concerning national security and national intelligence issues. The Richardson Review, as it's called, runs to over 1,300 pages and contains 204 recommendations. Now, Richardson believes that in order to implement his recommended changes, Australia will need to spend an additional 100 million Australian dollars over the coming 5 years. Just completing this review itself, the Richardson Review, that actually cost 18 million Australian dollars. I think a lot of lawyers would have gone home thinking about buying a new Mercedes after participating in that, but I shouldn't be so cynical about lawyers. Let me say a few words now just about the New Zealand view, because it's interesting about New Zealand, but also I think in casting light on what we're talking about. New Zealand maintains its own national security regime, but it's less complex than that in Australia. What I wanted to focus on is observing that Canberra, encouraged by Washington, appears increasingly attracted by the potential benefits of using the Five Eyes alliance to apply a level of synchronised geopolitical pressure. That is, Canberra and Washington have perceived how the Five Eyes security protection platform could be developed to launch some level of recurrent, coordinated Five Eyes political response on certain contentious issues concerning China above all. New Zealand differs from Australia on this issue. The New Zealand Prime Minister and Foreign Minister say they value the membership of Five Eyes as a security alliance, but New Zealand disagrees about using the security alliance to apply political pressure to China by issuing these joint geopolitical claims. They argue cogently that any group applying political pressure jointly should be done outside the alliance. Now let me move on to talking about briefly again the security framework in Singapore. And I think I can press this, yes. So Singapore offers enduring stability and an exceptional level of personal security for all residents, businesses and visitors, combined with an ethos of hard-working, widely shared prosperity. Singapore has assiduously maintained a core freedom from fear principle within its rule of law regime. This is the precept which was so gravely damaged in Hong Kong, indeed, in 2019. Pivotal part of the scheme that underpins the effective rule of law in Singapore is the national security framework. Around 20 separate laws help safeguard national security, the most important being the Internal Security Act. According to the International Commission of Jurists, the ISA creates executive powers which permit the President of Singapore on national security grounds to prohibit certain publications and to proclaim certain areas as security areas, subject to immediate special regulation. Also under the ISA, the President is able to order renewable detention without trial for up to 2 years in certain cases. This rules out bail completely, of course, and judicial review of such decisions is only allowed on strictly procedural grounds. Meanwhile, the media is rather more tightly regulated in Singapore than in Hong Kong. According to the Reuters Institute, the print and broadcast media are largely run by 2 major corporations which are associated with the governing party. Each of the 2 also maintains a dominant online presence. 2019, Singapore introduced a robust anti-fake news law to counter falsehoods, especially online, aimed at exploiting the city's fault lines. This was, according to human rights critics, a disaster for freedom of speech. So let's move on now to the case studies. Australia first. This Australian case study deals with the recent interaction between Australia's extensive national security regime and its university sector. It's widely recognised that Canberra's relationship with Beijing is more strained now than at any time since 1989. A recent article in a public policy journal in April this year was entitled "Peak Sinophobia in Australia?" The inquiring title of this article is attached to a spirited overview of current Sino-Australian relations, and it's written by a professor at Deakin University in Australia, Scott Birchall. Birchall begins by arguing that, and I quote, "Sinophobia in Australia, promoted over recent years by naive MPs, opportunistic academics, and jejune journalists, has now entered its neo-McCarthyist phase." The following text in the article confirms the aptness of the title, and Birchall then sets down chapter and verse to support the opening claim. A number of past high-ranking politicians from the centre-left of Australian politics, including a former Prime Minister and a former Foreign Minister, have expressed serious concerns about the inordinate influence the security services in Australia now exert over Canberra's decision-making with respect to China. A report in the Sydney Morning Herald in March this year explained how leading Australian universities had ramped up their interaction with ASIO dramatically over the previous 3 years due to the perceived escalating level of interference by China and other foreign governments. ASIO confirmed in the same report that it had had 60 engagements with leading Australian universities in 2020. A number of the universities, including the University of New South Wales, called for still more involvement of and help from the security services. New stringent guidelines have been issued and apply, especially with respect to China. This is, frankly, extraordinary. Moreover, it's difficult to find anyone in Australia raising concerns about the embrace of this spy-based influence on academic freedom within the mainstream media outlets. Birchall goes on to note how a number of leading Australian universities feel such a need to badge themselves as wholly patriotic that they are now paying handsomely for private risk assessment by a consultancy led by a former journalist who claims to be an expert on the operation of the Communist Party of China. This suggests that these universities consider that their own academic staff cannot be trusted to observe the new guidelines. Birchall continues, it's not clear whether this appointment is designed to appease Canberra's increasingly unhinged xenophobia or to preempt and hopefully ward off another government erosion of academic freedom. Let me now move on to Singapore and a quick review of a case there. We saw earlier about how the President has this power under the ISA to put people in jail for 2 years without trial or without bail. If circumstances justify it. A Singaporean citizen, Dixon Yeo, was detained in the US in 2020 for acting as an illegal agent of a foreign power, namely China. He served a sentence, was deported to Singapore, and was then immediately arrested when he arrived back by the Internal Security Department, and he was subsequently detained for 2 years under the ISA in January of this year. The Security Department said he had worked with a paid agent, namely China, a foreign state, sorry, namely China, and they explained their investigations were ongoing, and Yeo's extended detention was necessary to discover the full extent of his improper activities. So now I can come to the conclusion. I'll run slightly over time, I'm a bit naughty, but we're almost there. Based on the broad review of the Australian and Singapore regimes and these indicative case studies, I can now offer these concluding observations. First observation, all jurisdictions have a right and responsibility to protect their national security. Second observation, road traffic rules were uncommonly simple 50 years ago. Today they are far more extensive, detailed and complex. Legislating to protect national security exhibits a similar pattern. There is a tension in both cases between protecting the public interest and protecting individual interests. This tension is particularly acute with national security laws, as the punishments for breach can be remarkably severe. Third observation, Singapore has established what is by any measure a forceful and effective national security regime, which is widely accepted within Singapore. Many in Hong Kong stress how today Singapore looks like an attractive relocation destination in view of the application of the new national security law here in Hong Kong. I find this intriguing given the long-term, clear, very tight and successful national security controls which apply in Singapore. Fourth observation, comprehensive national security controls are being significantly enhanced at significant dollar cost within Australia, driven above all by a forceful narrative, especially evident since 2018, stressing the Sino or Chinese threat to Australian national security. The impact of these controls is growing, not least within the tertiary education sector. Finally, this review suggests, I believe, certain principles which can be used to guide how a national security regime should be employed. Where rigorous powers are conferred on a government under any national security law, one, those powers should be applied firmly when required, but not impulsively. Two, they should be applied dispassionately without fear or favour. Three, they should be applied without being coloured by any current disproportionate political fervour. And fourth, they should be consistently used in a circumspect manner. Thank you.
Madam Secretary, thank you very much for this invitation. Very distinguished members of the audience, friends, ladies and gentlemen. When I received the invitation, it was very much to my delight to speak on comparative law to a general audience. I've actually never done it before in my life. I only know two types of people who talk about comparative law: practicing lawyers. Why? Because it's profitable. And academics. Academics talk about comparative law. I have the privilege of being involved with a journal which for the last 125 years has been investigating how we compare laws. I know it's 4 p.m. and I only have, I think, 15 minutes after Richard. I'm actually very grateful to Richard for that, because as you can see, I have a very small paper. I'm delighted to be involved with that journal. It's 4 p.m. and I won't, I think, give you a mini lecture on how we compare laws. I think what we are interested in is what happens when we compare the national security law with its Anglo-American counterparts. And the moderator, Professor Chu, thank you very much for that very kind and undeserved introduction, asked me to say something about extraterritoriality. And I think it is because many people who talk about the national security law outside Hong Kong are very concerned about the extraterritoriality clauses in the national security law. We've heard mention earlier today about Articles 37 and 38. So let me begin by saying something about that. I will then say something about the history of Anglo-American national security laws, and then I will make one point. And that point is how notable, how unusual actually, when you compare the national security law with its Anglo-American counterparts. What happens when you actually make the comparison? In terms of extraterritoriality, the most famous English case involved a person called William Joyce, who was broadcasting from Germany in order to demoralize the British public during the Second World War. Words to the effect, people of the United Kingdom, you are kaput. Now, they caught him after the Second World War, and they tried him after the Second World War. And Lord Jowett, who then was Lord Chancellor, said, it's not a question of where he had broadcasted these messages from. He was broadcasting from Germany, but who he is. He is a British national. Even though he probably obtained a British passport by fraud, he is still a British national and therefore has the right to claim the protection of the crown. And they hanged him. The way I described it in a journal called the Law Quarterly Review was by saying it was not a question of where. It is not where treason can be committed, but by whom. And if it is a national, by and large, it is uncontroversial. Under the Terrorism Act of 2000 in the United Kingdom, that act extends to both nationals and as well as to residents for bombing, for example, for terrorist financing, and they amended it to extend it to such things as engagement in terrorist training abroad. So you have your own nationals go abroad to train to do some very undesirable anti-social things in the United Kingdom or against British embassies abroad. Now, on this point of extraterritoriality, the imagination of Anglo-American law, how Anglo-American lawyers imagine themselves, is quite different from how we might see it from Hong Kong or from China. The idea in Anglo-American law is that there is a strong presumption against any extraterritorial laws. And so if we were to take the jurisprudence of the United States Supreme Court between 1983 and 2021, for example, we find that in 1983, Justice Souter, in a case called Hartford Fire, said in the context of American antitrust competition laws, if you can obey American law wherever you are, and it is not unlawful for you to obey American law wherever you are, then you should obey American law wherever you are. Now, that was a high point in 1983, and by the time we got to a case called Empagran in 2004, the same Supreme Court decided to pull back from that position. Most commentators say because by that time, half the world had already adopted American law, so you didn't need to take this approach telling them to obey American law, to comply with the Sherman Act of the United States, because competition law was to be found all over the world. Lawyers in Fiesole, lawyers in Seoul, in Tokyo, lawyers in Hong Kong talk about competition law today. That is American law. By the time we got to 2013, in relation to something called the Alien Tort Statute or the Alien Tort Claims Act, allowing people to bring human rights lawsuits against Royal Dutch Petroleum, for example, in a case called Kerbal, we finally see the tide of American jurisdiction going out, because in Kerbal, the United States Supreme Court basically applying another judgment called Morrison from 2010 said that it was not going to assert jurisdiction unless a particular matter touches and concerns the United States with sufficient force. And so if you are standing from over there, looking at the world from the viewpoint of Anglo-American law, in this context, from the viewpoint of American jurisprudence, you have this idea that people shouldn't extend their laws abroad. So when you look at something like the national security law, it looks odd because it has these extraterritoriality clauses. But that is only the impression we get from within Anglo-American law. We feel American law in Hong Kong. We have felt it in Hong Kong and in China in recent months and in recent years. The executive order of July 14th, 2020 was made because a particular statute exists called the International Emergency Economic Powers Act. Now, when we trace the history of the International Emergency Economic Powers Act, we find that it came from trading with the enemy legislation. So the sanctions we talk about today, American sanctions imposed on Hong Kong, come from a national security law, an extraterritorial national security law. We don't usually think of sanctions as national security law, so it is not unusual, and we feel it acutely. As for the history of Anglo-American national security law, the United States Constitution has a treason clause, very famous treason clause, stating that you'll need 2 witnesses or a confession in open court to be convicted of treason. Early treason cases involved even a prosecution against a former vice president of the United States, Aaron Burr, who was vice president to Thomas Jefferson. Later cases, Second World War cases, involved giving comfort, aid and comfort to the enemy. There was a case in 1947 called Haupt. A father was sheltering his son. In more modern times, a famous case was the United States against Rahman. And Rahman was a case that was related to the World Trade Center bombings. It was a 1999 case, and the persons in that case were prosecuted for seditious conspiracy. Now, what was interesting about Rahman was that it cited another famous case called Dennis, which was a 1951 case. Why were the people in Dennis being prosecuted? They were being prosecuted for what they planned to teach. They planned to teach Marx. They planned to teach Lenin, and so on. Now, you might have thought in the United States of America, even in 1951, that there is such a thing called freedom of expression. And the United States Supreme Court said, yes, they are free to discuss Marx, they're free to discuss Lenin or Engels or Stalin or whatever they might wish to discuss. But they crossed the line when it became advocacy to overthrow the government. And in that case, in Dennis, the United States Supreme Court also threw away something called the clear and present danger test. There is no need for a clear and present danger. I mention this not as criticism. I mention this because there is a certain misimpression that in the national security context, pride of place is given to the protection of rights. Usually when you find yourself in a national security context, it is not. Rights don't usually matter very much in a national security context, unfortunately. In the case in Dennis, they were imprisoned for many, many years. In Rahman itself, in 1999, they were imprisoned for many years. The evidence used for a prosecution of seditious conspiracy included speeches and writings. And again, you might think, well, people have the right to express themselves, to speak or to write. And the Supreme Court said, yes, but we can still use what they write and what they say to prosecute them. We can still use it as evidence. In the United Kingdom, in 2001, there was the Anti-Terrorism, Crime and Security Act, sections 21 to 23, which have now been repealed. But for those few years, we saw that people could be deprived indefinitely of their liberty without trial on mere suspicion, on the basis of a certificate issued by the Secretary of State, which is not reviewable, which was not reviewable before the courts. We had that. And the history of preventive detention in the United Kingdom is long and it is tawdry. It was used in relation to Northern Ireland. The United Kingdom and Ireland was a famous case, and across the Commonwealth, I think Richard has spoken about that. We see the legacy of prevention, indefinite detention without trial. Today, in the United Kingdom, I'll try and wrap up quite quickly so that my dear friend Chow Yun will have his 20 minutes. In the United Kingdom today, there are people who say that the Treason Acts are insufficient. The original Treason Act of 1351 is almost 700 years old. If we take a look at Archibald or Blackstone's Criminal Practice, both of those very authoritative works will say that prosecution for treason is hardly to be expected. But there are people today who are now suggesting, in very influential places, that the treason acts should be reformed and that there should be a crime of betraying one's country and helping one's enemies. So let me, if I may come to my point, to conclude, when we compare laws, what are we doing? Are we even comparing the same thing? Are we comparing like with like? When people outside Hong Kong look at the national security law here, they say, oh, look at the provisions on extraterritoriality. More usually, they zero in on Article 55. That's the provision that we've heard mention of this morning. When does the jurisdiction of the Hong Kong courts run out? In only 3 highly exceptional situations. For example, if the government is unable to enforce the national security law, now that it must take a very extreme situation. or where there is a major imminent threat to national security. That's a very extreme situation where there is a foreign country or external power that is involved. These are all highly exceptional situations, but the most interesting question is why? Why do we have Article 55? Because Hong Kong is a region of a country. And that is the simple explanation. There is no comparison to be drawn. It is an inappropriate comparator. What is an appropriate comparison is this. Article 4 preserves our fundamental liberties. It preserves our fundamental liberties by reference to the basic law. It preserves our fundamental liberties by reference to the provisions of the International Covenant on Civil and Political Rights as applied to Hong Kong under law. When we compare that with what happens whenever there is a national security situation in the history of Anglo-American law, we find a very stark comparison. And that is my only point about comparative law. Thank you very much. Thank you. Yes.
Thank you, Chuning, for keeping the 20 minutes for me. And also thank you, Chair, for the introduction. Good afternoon, ladies and gentlemen. It is a great honor for me to be invited to speak on this very important occasion. National security law establishes the way that the state handles the threats to its government, its value, and its very existence. The focus of the concept of national security is on state values, which are protected against armed attack from outside, armed rebellions from within, subversion, and economic constraints. Comparative studies have been able to characterize legal similarities apparent across legal systems. Thus, I hope this session will be able to help to put our national security law against international background. In a way, national security law is no more so national. In view of the standardization of vital state and national interests and national values, and mechanisms and organizations responsible for security at both national and at both national and international levels. My learned colleagues have made excellent presentations on the situations in several jurisdictions. In this presentation, I will briefly give an overview of the European continental countries and discuss certain issues from the perspective of international law, including extradition and extraterritorial application of the law. I know the issue has been discussed actually this morning by Professor Huang Feng, and also actually Professor Lin Chunlin has also touched upon. National security has been a major issue since World War II in Europe. Almost all European continental countries have made legislation for this purpose, which has formed the so-called national security legal system with European characteristics, different from the comprehensive legislation model in other jurisdictions. The European continental countries do not generally make a comprehensive law on national security, but includes relevant provisions in separate national laws, in particular criminal law. The European continental countries have been continuously improving the legal system for the protection of national security. Two major features could be discerned. First, they emphasize the importance of maintaining constitutional order. The priority is on the maintenance of the basic political system and core values based on the Constitution. Second, they rely on the support of powerful enforcement authorities, though such enforcement mechanisms differ depending on their historical and traditional background. For example, France emphasizes its work on terrorism and thus takes measures on cracking down terrorism and other national security-related crimes, while Germany focused more on extremism due to Nazi in history and thus more frequently take preventive measures. When it comes to guiding ideology, France focuses more on a comprehensive concept of national security, including political and social security, with Germany more on traditional political security. Now I take Germany as an example to elaborate the national security regime. I must admit, this is a very brief and preliminary examination of relevant provisions in this continental country. German criminal code provides for the offense of high treason against the federation, against the land with or without force, to incorporate the territory of the land in whole or in part into another land, or to separate a part of one of the land from it. The code further provides for the offense of preparation of high treasonous undertaking. On the extraterritorial effects, the code specifically provides that they apply to acts committed abroad, regardless of which law is applicable as a place where the offense was committed. German criminal law applies to the offenses committed abroad, including high treason. Similar arrangements have been made to other offenses. The code provides for the offense of preparing serious violent offenses endangering the state. The code applies if the preparations are made abroad. The code provides for another offense of treason, espionage, revealing state secrets, treasonous espionage, and spying out state secrets, divulging state secrets, treasonous activities as agent, working as agent for intelligence service. The code further provides for the offense of sabotage against means of defense, intelligence activities endangering national security, images endangering national security, etc. Regardless of which law is applicable as a place where the offense was committed, German criminal law applies to such offenses committed abroad. When it comes to various rights of the accused, the criminal code allows exclusion of defense counsel's participation in cases involving dangers to national security. The Court Constitutional Act provides for the right to exclude the public from hearing if there's possibility of endangerment of state security, the public order, or public morals. If a person is urgently suspected of a crime and there is a reason for detention, such as the danger of absconding, the prerequisites for pretrial detention are met. When I prepare for the presentation, apart from Germany, I actually also look at the situation in the Netherlands and France. I think similar provisions I can find out actually very similar to those that have been put down in the German criminal code. Now, I will move to specific issues from the perspective of international law. First, open trial. Article 14 of the ICCPR provides that the press and the public may be excluded from all or part of a trial for reason of morals, public order, or national security in a democratic society. But any judgment rendered in a criminal case or in a suit at law shall be made public, except where the interest of juvenile persons otherwise requires. So national security law is compatible with the ICCPR that it presumes a trial in open court, but allows closure if issues of public order or state secrets arises, and it provides publication of judgment in any event. Now, we move to the second issue, extradition. Several countries suspended their extradition treaties with Hong Kong after the implementation of the national security law. It should be noted that Hong Kong's existing legal protection with regard to extradition remains valid, including the application of the ICCPR and ICESCR. Furthermore, extradition requests are restricted by the judicial processes of different requested jurisdictions. And thirdly, extradition requests involving offenses under the national security law may be rejected on the grounds of a political offense exception. It is a well-established principle in international law that political offenses are exempted from extradition. This is also the case in Hong Kong. For both agreements which are still in force and those which were suspended, there is a common or similar clause providing that a person shall not be surrendered if the requested party has substantial grounds for believing that the offense of which the person is accused or was convicted is an offense of a political character. Of course, we can have a lot of discussions about the understanding of political offenses from the theoretical and practical point of view. Now, we move to the last issue, the extraterritorial application or jurisdiction issue. Part 6 of Chapter 3 of the National Security Law includes 3 articles that provide for possible extraterritorial effect of the law. The territoriality of criminal law is fundamental, which is an essential attribute of the state sovereignty. That is, a state has jurisdiction over all persons and things within the territorial limits. Extraterritorial criminal jurisdiction is, however, not forbidden in international law, or we could also say is well-founded in the international law. The jurisdictional principles provides the basis for applying criminal legislation to crimes committed abroad, including the territorial principle, the nationality principle, the protective principle, and the universality principle. In a way, it shows that the exercise of extraterritorial jurisdiction requires a sufficiently close connection between the offense and the legislating state. Now we look at the 3 articles in national security law. Article 36 is not controversial since it clearly follows the territorial principle in view of the close connection between the crime and the state, including the situation with only the consequences of a crime in the territory of Hong Kong, even though the crimes may have been committed in a foreign state. For offenses committed on board a vessel or aircraft registered in Hong Kong, this is also well recognized as quasi-territorial jurisdiction and natural extension of the territory of the state. I remember there were some discussions regarding the outer space or the space object or the space station. I have always clarified that it's not possible at the moment to use the term nationality in the space station because we will very soon have our own space station which came into operation next year. A state may apply its laws to its nationals even when they are abroad. This nationality principle has been well accepted internationally, though the exercise of such jurisdiction should not infringe territorial sovereignty of another state. Article 37 is exactly the application of this principle. Hong Kong permanent residents, even of non-Chinese nationality, enjoy a wide range of legal rights under the laws of Hong Kong. Thus, there is solid grounds to exercise the jurisdiction under this article. The extraterritorial jurisdiction under Article 38 is a most controversial provision, which applies to offenses committed against Hong Kong from outside Hong Kong by a person who is not a Hong Kong permanent resident. The arrangement is in accordance with the protective principle. It is well settled that a state may apply its law to the conduct of a foreigner committed outside its territory that endangers national security. National security has always been the primary state interest covered by the protective principle. The exercise of extraterritorial jurisdiction is within the scope of state sovereignty. A state is in a position to judge what endangers and how to protect its own security. However, the difficulty lies in the lack of clarity and consensus with regard to the application of the protective principle, such as the range of state interests to be protected, the types of crimes to be punished, etc. Normally, we would expect only state interests that are essential or vital to the state, and such crimes include espionage, acts of terrorism, murder of governmental officials, etc. A state should carry out the protection of national security in a manner that is consistent with international legal obligation. Article 4 of the National Security Law makes it very clear that human rights should be respected and protected in safeguarding national security in Hong Kong. The ICCPR and the ICESCR shall continue to apply. So to conclude, all countries have some kind of national security law or concerns over national security. Thus, this is not something new. Major problems lie in its enforcement. For example, the protective principle is recognized in international law. However, how to interpret and apply the criteria of the terms such as significant interests, essential interests, and necessity, etc. In general, legal protections with regard to extradition or extraterritorial applications are in place, including the continued application of the ICCPR, protection of human rights. Thus, more important for us now is to look into its implementation, not simply the law per se. We are still in the early stage of its implementation. We do not yet have a full picture of how the national security law will be interpreted and applied by the court. I hope the comparative studies of the national security law in other jurisdictions may help the implementation of this law. So with this, I conclude my presentation. Thank you very much.
Thank you. According to the program, we'll have 15 minutes for panel discussion. And while listening to you, I prepared a few questions to you. I'll start with Richard first. Now, Singapore is quite similar to Hong Kong in size and also in legal system. Singapore experience is relevant to us, but how? What we can learn from Singapore?
I think, well, I agree with you about the similarity. So let's start there. That's the easy part. Each jurisdiction had over 150 years of experience of being run by the British with the British common law system and so on. They're of similar size, similar economic functions, and in both cases, there's a majority Chinese population. The Singapore experience, I think, when we move beyond that, what is significant to me is that the use of the national security regime is much more settled. We've had it now for 1 year, the new national security law. We had the old British laws, which are still on the book, but are frankly quite outdated in the modern circumstances. Singapore's kept right up to date with its lawmaking, as I understand it, witness the new law regulating online content. But I think in terms of the thrust of the national security law, the law appears to be well accepted, perhaps not by people like Mr. Yeo, who's just been put in jail for 2 years and may have to stay there for 2 years and 2 years and 2 years. But for most people, it's seen as part of the system that underpins the stability and prosperity. So it's relatively well accepted, and I think I'm no expert in the operation. My reading is general, but I think the reasons that this may be so are that the law is used in a principled way. It can be very harsh, but it's not used in an impulsive way, and it's used in cases where the government sees something in the bud, or they can control something, but it has limited impact on the overall population in terms of adverse impact. But people mostly see, if they think about it, the positive impact of being part of maintaining the stability. So we come to Hong Kong, the test is going to be over the next 5 years, I think, to see how the national security law works out here. So far, despite all of the wild and somewhat alarming statements from the likes of Dominic Raab and others who think like him, it seems to me to be working very well. It's clearly done far more good than harm. It's not cost-free. There are restrictions on what we can and cannot do compared to over a year ago, but it's working in the way that it's meant to. But as I say, it's going to take time. I think the point made by Grenville Cross earlier is very important too, that we're going to have to wait and see how the courts deal with it. How do the courts deal with it and apply it? So that we've got more certainty coming from the experience. And in that sense, I think if we can reach the point where Singapore is at, I don't want to make Hong Kong quite like Singapore, but if we can reach that point over the next 5 years, that will be a good benchmark.
Thank you. And let's talk more about America. And America's example, right, has made quite a number of national security law. And can you summarize as the rationale that support the practice that America make its laws extraterritorial?
We have to leave the courts out of it. The courts.
You can talk about the court as well.
We have to leave the courts out of it. And it really depends upon the particular. It depends on who is in the White House. If we take the Bush administration, for example, what did the Bush administration do? It labeled certain persons as unlawful combatants. This is very deliberate. So all you guys are unlawful combatants. That means 3 things. First, we don't think the Geneva Conventions, which protect combatants during wartime, we don't think that's part of the law of the United States, because those are treaties. For us in Hong Kong, it may be the International Covenant. We say the provisions as they have applied continue to apply. We're doing the opposite. For the Bush administration, these treaties which ordinarily would apply, they're not part of United States law. That's the first move. The second move was to say that even if they did apply as American law, these guys will not be protected because they're not really combatants. They are unlawful combatants. So they don't even have combatants' rights. And then they make the third move. Okay, so if international humanitarian law doesn't protect them, even though they are combatants, you call them combatants, but they are unlawful or illegal combatants, then do they have any human rights at all? Oh no, They're combatants. So it is unusual to apply international human rights law where international humanitarian law, which applies in wartime, should apply instead. Now, if you followed all those convoluted moves, all those somersaults, you will see that what the Bush administration was trying to do was to get out of having to accord any rights to anyone suspected of having any links with Al-Qaeda. All these guys were operating abroad. All of them. That example came to a head in a case called Hamdan. There was another case called Hamdi, and Hamdan. In Hamdan, the US Supreme Court basically said, carry on. You can detain, you can deprive them of liberty without any ordinary trial. The rest, we all know where they were detained and so on and so forth. I wouldn't use the United States as guidance. I really do prefer the national security law here. Thank you very much.
Thank you. You correctly mentioned the court. Precisely what kind of role the American court has played in maintaining the national security?
What kind of role? Sorry.
Yes, what kind of role? I think active, proactive, conservative?
Well, as I mentioned in the case of Dennis, there was an earlier case that said, okay, you can deprive people of their rights in a national security context, what we call a national security context, if there is a clear and present danger to the United States. And Dennis, in 1951, dealing with a bunch of people who wanted to teach Karl Marx, said, no, there's no need for that. It's a very uncomfortable piece of the history of American jurisprudence, but it is still there. And in Dennis, they said, well, you can discuss Marx, but we say that you have crossed the line, and in planning, not even teaching, planning to teach, you have crossed the line into advocacy of the overthrow of the US government. In Rahman, if I have the liberty to say something or to write something, what does it mean to say that I have that liberty, but you can use what I write and what I say and say to me, you have committed seditious conspiracy. So what does that freedom mean? So no, I don't think we should look for examples there.
Thank you. And one of the many concerns over national security law is the protection of human rights and individual rights and liberty. And for example, political offense is related to it. Now, I'd like to ask Professor Zhao to clarify this point or definition of political offense, whether the suspect of a political offense should be extradited to or from Hong Kong. Thank you.
Thank you, Chair. Yes, I think the political offense, I think, is quite an important issue. Internationally, or I refer to the international law, I think it's quite well established that non-extradition of a political offense, I think, is well established. So I think it's clear that there will be no extradition of political offense. But the problem lies in the understanding or interpretation of the political offense. How do we understand? How do we interpret? At the moment, at the international level, political offense can be divided into pure political offense and relative political offense. Pure political offense is, in a way, I think, of non-violent nature. If not for its political considerations, it would not constitute a crime.
Last one.
But when it comes to relative political offense, it always involves one or more common crimes with political consideration. So this is one major issue that we have to look into, the relationship between the common crime and the political factor, political consideration. How close are the common crime and the political consideration? Well, at the moment, we do not have a clear definition for the political offense, relative political offense, but internationally, the trend is quite clear that the public opinions or the scholars have reached some kind of consensus regarding the political offense or the political offense exception. That means the international society are increasingly intolerant of violent crime, or violent terrorism. And increasingly, we can find out that the international society will exclude violent conducts from the benefits of the exception.
Thank you. And I think you still have 10 minutes. Now, I have a last question to all three panelists. Probably you can offer your opinion. That is, legal professionals in Hong Kong like to talk about, that is balancing between the interest, public interest, and the individual rights and freedom. So you are free to speak. Quick. We can be quick. Yeah.
Okay.
It's a very important issue, but I'm concerned with many.
The balancing, we're going to have to keep working on that. We're going to have to pay constant attention to it on both sides, protecting national security and individual rights. I think we'll have to learn to live with a loss of a certain amount of scope to do just what we want to do whenever we want to do it. There's no question about that. But I think a very good thing is that we now know where we stand. We certainly know where the really fat red lines are, and these are doing things which endanger national security, trying to cause alarm and spread alarm, and actively doing this sort of thing and disguising it, or to use the current word that's used a bit, beautifying that sort of behaviour, or to be recognised for just doing that. But there are going to be tensions around the borderlines. I don't think there's any doubt about that. And I think the other thing that's going to happen is we'll have to be able to look at behaviour that may be inflammatory, but it doesn't have much impact because of who it's coming from, or because it's just an individual saying something very silly. We're going to learn to feel our way with these sorts of things. But I think more seriously, looking at the, many people would say the balance of rights and the state's rights in Singapore are tilted too heavily in favour of the state. But we can learn from the way that they've gone about working out how to maintain that balance. We may not want to follow it, but at least they've got a clear idea of what the position should be, and they've clearly convinced people that this is in the interest of all Singaporeans.
I think there hasn't been a shortage of people who have spoken for the judges without the judges having really spoken. People who say, oh, look at the national security law. The judges cannot do their job. Lord Reid issued a statement very quickly and gave us heart. He said, let's wait and see. Lord Neuberger said, there is enough oxygen for me to sing. And he said that in an incredible debate with Lord Faulkner, which I would recommend to everybody. It was an inner temple event. It was very informative. We have all seen what Jonathan Sumption has written in the press. I was asked this question, speaking to the Statute Law Society 2 weeks ago. What are you going to say about Lady Hale? And all I said was, it is a matter for the individual judge to decide. So let's let them decide. Let's not preempt it. Let's see how they do it.
Thank you. Joe?
Yeah, well, I think balancing the public interest and individual rights can be a very difficult process. And of course, I think this happens not only in the national security law field, but also in many other fields. When we look at the protection of the public interest, actually the concept of public interest is changing over time. So we will need to look into the social circumstances, the specific social circumstances to define the understanding of public interest. But individual rights, again, I think also quite important. But if we look at the ICCPR or some human rights documents, it has already mentioned that there's a possibility of derogation from these rights in time of emergency, such as endangering the national security, etc. So when it comes to the balancing exercise, I think it's rather important to take a two-step exercise. The first step is to look at the necessity, whether we really need to take such measures. Second, the measures that were taken should be proportionate to the purpose they achieve. So proportionality test is rather important as a second step to balance the public interest and individual rights.
Thank you. And I'm advised to keep on discussion. And I have a very good question, I think, since we are supposed to be expert of comparative law, right? To what extent really this foreign experience, foreign systems are relevant to Hong Kong?
Why don't you go first?
I would have thought that by now everyone would have wanted me to shut up. I think what we have found is that sentiments are heightened in national security situations. What we have seen abroad is that even when legislation curtails rights, in the UK context, in relation to the Anti-Terrorism, Crime and Security Act, which I mentioned earlier, the United Kingdom entered a derogation under the European Convention on Human Rights and Fundamental Freedoms. That triggered Section 1(2) of the Human Rights Act in the United Kingdom, disapplying the Human Rights Act. They entered a derogation under the International Covenant on Civil and Political Rights. All of those things were done with popular support. The people who spoke against the Anti-Terrorism, Crime and Security Act were a minority. Those situations, if I may say so, mark out the differences. We don't have that kind of broad public support, that heightened sense of security when these sorts of legislation, which you wouldn't have thought acceptable ordinarily in the United States or in the United Kingdom, were simply accepted. The conditions matter.
In addition.
Well, comparative laws, I think they are worth, it's important to look at things comparative, particularly legally. Two levels, I would say. One is what I'd call the basic political or geopolitical level, I think more geopolitical. So today, where various persons in the US say we're in the middle of a new Cold War, or statements of that sort, then it's important to push back against all of this finger jabbing and waving and pious sermons that we get from Washington, to point to how they deal with the same things in their own laws. We've just seen that today. That's very important. And then at a more technical level, we can learn to legislate far better by looking at laws from offshore, but we need to take into account the local context offshore and the local context here.
Okay, and I'm asked to conclude, and I use 2 minutes to conclude. It's I want to thank the panelists for their informative presentation and meaningful and highly relevant comparison and the insightful comments and observation. I also want to thank the audience for having followed these presentations. Taking this opportunity, I want to make a few remarks to conclude. First, Hong Kong national security law has been promulgated only for 1 year, and the implementation of the law should be our focus in the future. In order to consolidate this the positive social effect brought about the national security law, the SAR government, led by the chief executive, should lead the implementation of the law, improve the relevant systems. Second, Article 23 of the Basic Law and Hong Kong national security law provide a macro framework for legal resolve and national security. The government needs to continue to complete unfinished national security legislation task and fulfill its constitutional responsibility. This can be through the reopening or reintroduction of Article 23 legislation or respective amendment to existing Hong Kong laws, including crime ordinance, etc., etc. And the third, in the process of law enforcement, we should fully consider the value of human rights protection and follow the basic standard and the rules recognized by the international community to achieve a reasonable balance between the national security interest and the protection of individual rights. Fourth, we should study the experiences and the lessons of other jurisdictions and improve the legal system governing national security in Hong Kong. Fifth, issues that need to be studied further include A, the possible impact and influence on the national security law on the current constitutional system and the human rights. B, the impact and the influence of national security law on Hong Kong's judicial system and the principles. C, the coordination between the national security criminal law system and the Hong Kong criminal law system. D, the impact of national security law on the current criminal justice and the litigation procedure in Hong Kong. We should plan ahead and under the promise of the basic law of Hong Kong, adopt a proactive enterprising attitude. We should carry out a theoretical exploration, propose practical strategies to ensure the stability of Hong Kong and the long-term development of one country, two systems. Thank you.
多謝朱國斌教授、高禮文教授、孫令黏教授以及趙雲教授。現在有請中華人民共和國香港特別行政區政務司司長李家超先生為今日嘅法律論壇發表閉幕致辭。有請政務司司長。
尊敬嘅梁振英副主席、方建明副特派員、譚耀宗常委、譚惠珠副主任、鄭若驊司長、各位嘉賓、各位同事、各位朋友，香港國安法已經落實咗1週年。律政司今日舉辦香港國安法法律論壇，正好係回顧同埋展望國安法同香港發展嘅大好機會。我首先感謝各位參與今日嘅論壇，亦都衷心感謝中聯辦同埋駐港國家安全公署全力支持。香港國安法嘅實施有3個重要範疇，即係防範、制止同埋懲治危害國家安全嘅行為同埋活動。喺今日論壇嘅上下午各個環節，各位來自內地、海外同埋香港嘅講者，從法律角度同埋執法角度， 就香港國安法嘅實施進行咗深入嘅討論。我喺呢度感謝各位嘅真知灼見，你哋嘅分享令到我哋大家獲益良多。香港國安法嘅實施立竿見影，扭轉咗過去肆意鼓吹港獨同埋喺社會嚴重暴力嘅亂局，社會都見到破壞秩序同埋社會安寧嘅行為大大減少，社會恢復穩定。呢啲證明咗執法可以達到制止同埋懲治嘅效果。然而7月1號晚上發生嘅孤狼式恐怖襲擊，兇徒喺大街上邊持刀去襲擊一名警員，企圖謀殺，導致佢嚴重受傷。呢件事件令人髮指，亦引起社會廣泛關注。呢件案亦都顯示國家安全威脅雖然受控，但係風險依然存在。我留意到有啲人更加鼓吹同埋支持呢啲孤狼式嘅恐怖襲擊，散播仇恨意識，更加嘗試美化或者英雄化呢啲涉及意圖謀殺嘅暴力行為，無疑係助長同埋鼓勵呢啲極端行為，威脅香港嘅安全同埋秩序。所以我哋必須共同努力，阻止本土恐怖主義喺香港滋生。要徹底根除香港特區嘅國家安全威脅，我哋必須要居安思危，有效防範危害國家安全嘅行為同埋活動。呢一啲並唔係一兩個部門嘅工作，亦都唔淨係政府嘅工作，而係整個特區嘅共同責任。就此，香港國安法嘅第3條訂明，香港特區行政機關、立法機關、司法機關應當依據香港國安法同埋其他有關法律規定，有效防範制止危害國家安全嘅行為同埋活動。香港國安法第6條亦都訂明，維護國家主權、統一同埋領土完整係包括香港同胞在內嘅全中國人民嘅共同義務。喺過去1年，整個政府團隊已經喺多方面着手工作，將維護國家安全嘅概念融入政府嘅工作裏邊。例如，公職人員嘅管理方面，政府已經要求所有政府官員同埋公務員依法宣誓同埋作出聲明，確認擁護基本法、效忠特區，以及對特區政府負責。另外，政府已經修訂法例，加入要求所有區議員都需要依法宣誓擁護基本法、效忠特區。政府亦都會逐步界定同埋要求若干合適嘅法定機構嘅人員，以公職人員身份依法宣誓或者簽署文件，確認擁護基本法、效忠香港特區。我哋亦都正加強為公務員有關香港國安法嘅培訓，幫助公務員全面了解香港國安法，增強佢哋對國家安全嘅意識。喺學校方面，教育局已經喺今年3月向全港嘅學校發出通告，就維護國家安全提供學校行政同埋教育指引，並公布國家安全教育喺學校課程嘅推行模式同埋相關嘅學與教資源，協助學校落實相關措施，提升對國民身份嘅認同感同埋建立國家觀念。此外，因應香港國安法實施，政府已經修訂電影檢查條例指引。如果影片可能危害國家安全，或者危害維護國家安全，電影檢查員應該得出 影片不宜上映嘅結論。民政事務總署亦都協助舉辦社區參與活動，向社會各界解說香港國安法。各個政策局同埋部門會繼續努力推進相關工作，務求確保政府喺各方面嘅施政都能夠做到香港國安法對特區行政機關嘅要求，有效防範、制止同埋懲治危害國家安全嘅行為同埋活動，培養社會整體嘅國家安全同埋守法意識，必須推展到政府以外，推動市民大眾一齊維護國家安全。除咗上述針對政府同埋公務員團隊以及學校嘅培訓同埋教育工作之外，政府透過不同嘅機制同埋計劃，將國家安全同埋守法意識帶到社會各個階層。舉例而言，由於香港國安法係列於基本法附件3嘅全國性法律，同憲法同埋基本法係環環緊扣，係香港市民必須認識嘅重要課題。因此，政府會善用基本法推廣督導委員會嘅平台，統籌制定憲法、基本法同埋香港國安法嘅推廣策略同埋計劃。此外，不同嘅政府部門或者機構，亦都透過舉辦不同嘅活動，大力推廣維護國家安全嘅概念，包括由特區維護國家安全委員會舉辦嘅全民國家安全教育日嘅活動，由保安局策劃並且喺上個禮拜推出嘅香港國安法1週年網上展覽，以至律政司今日舉辦富有意義嘅法律論壇等等，呢啲都係向香港市民介紹國家安全嘅理念同埋香港國安法嘅多方面嘅項目。喺未來，各政策局同埋部門都會繼續推進相關工作。隨住香港社會同心協力落實香港國安法，我哋必定能夠構建全民國家安全意識，令一國兩制呢一個香港特區一直賴以成功嘅制度可以行穩致遠。一國兩制係保持香港長期繁榮穩定最佳嘅制度安排。而過往一段頗長嘅時間，港獨分子肆無忌憚，加上外部勢力插手破壞，令香港受到前所未有嘅破壞同埋損害，亦都令到香港成為國家安全嘅缺口。制定落實同埋執行香港國安法，目的就係要打擊危害國家安全嘅勢力，讓香港特區能夠重新聚焦一國兩制嘅根本。我必須強調，香港國安法喺維護國家安全嘅同時，市民喺特區一貫依法享有嘅自由同埋權利獲得充分保障，包括對特區政府作出批評，以及如常進行國際交流、學術交流同埋自由營商等等。香港國安法嘅第4條清楚訂明，香港特別行政區維護國家安全意識，應當尊重和保障人權，依法保護香港特別行政區居民根據香港特別行政區基本法和公民權利和政治權利國際公約、經濟、社會與文化權利嘅國際公約，適用於香港嘅有關規定享有嘅包括言論、新聞、出版嘅自由、結社、集會、遊行、示威嘅自由在內嘅權利同埋自由。香港國安法嘅實施，發揮咗強而有效嘅震懾力，使香港迅速回復安全穩定，成績有目共睹。香港國安法亦使香港經濟可重新出發。同2019年年底比較，證券市場每日成交金額上升140%，市價嘅總值亦都上升約40%， 初創企業嘅數目亦都上升咗6%。香港更加被評選為最受歡迎仲裁地點嘅第3位。穩定嘅社會亦都有利香港把握十四五規劃綱要所帶嚟嘅機遇。十四五規劃綱要表明支持香港更好咁融入國家發展大局，包括建設粵港澳大灣區呢一個國家開放程度最高、經濟活力最強，以及擁有超過香港10倍人口、生產總值達17000億美元嘅龐大市場。國家安全同埋政權安全係不可分割嘅。要真正達至國家安全，管治權必須掌握喺愛國者嘅手上邊。全國人大常委會喺今年3月30號通過新修訂嘅基本法附件1、附件2。立法會喺5月通過落實完善特區選舉制度嘅本地法律。完善選舉制度將有助立法會恢復佢嘅憲制職能，作為行政機關同埋立法機關之間進行理性互動嘅平台，以切實提升管治能力。政府現正全力以赴籌備未來嘅3場選舉。呢1年內，中央嘅2大舉措穩住咗香港嘅大局，為全面準確貫徹一國兩制、港人治港、高度自治方針奠下咗重要同埋堅實嘅基礎。我深信喺實施香港國安法、完善選舉制度同埋落實愛國者治港之後，香港將會迎來建設同埋有效施政嘅新篇章。只要大家攜手起嚟，團結一心，努力維護一國兩制嘅全面貫徹落實，喺國家嘅全力支持之下，國安家好，一國兩制必定會行穩致遠，香港亦必定會長期繁榮穩定，欣欣向榮。最後，我特別感謝律政司所有嘅同事為籌備呢一個論壇所做嘅大量工作，使今日嘅論壇圓滿成功。我亦再次感謝各位專家講者同我哋今日嘅珍貴分享，多謝各位。
多謝李家超先生，現在已經嚟到香港國安法法律論壇嘅尾聲。再次多謝各位貴賓講員，亦都非常多謝各位現場嘅嘉賓以及嚟自世界各地嘅網上參加者嘅支持。我哋深信喺香港國安法嘅保障下，香港必定可以繼續穩步前行，再創高峰。